So today's article is an extension of what we discussed a few days ago about fundamental rights, the approach therein. So in today's article, you will have an interesting way of looking at the concepts, and I'll give you a brief context. What is my expectation today from you? I'll clearly tell you. I'm not going to just summarize the editorial, give you a framework, and leave it at that. Let's say you are sitting in front of the article writer. I want to understand how will you counter with logic. I want you to think. Okay. So first I'll tell you the background. This article, A Shadow on Our Rights. This is taken from the Indian Express. Okay. So this writer's name is Pratap Bhanu Mehta. If you have PubAd optional, you would have known him. A very famous writer. So he is criticizing a order from the Supreme Court. Okay. Before I get to this, I'll just briefly tell you the case context, and let's come back to that so that you will be able to understand the situation better. Ali Khan, Mahmudabad was a state of Haryana case. There is one case. Okay. Whenever you see the word state in judiciary, it is a case where the sovereignty is in question. So the activity or any dispute happening there is between the state and an individual. It means the social contract. There is a breach in that contract. See, you have an agreement. I will give you this, you give me this. Only then the contract will be intact. Yes or no? If something is done to breach that contract, there should be some corrective measure. Yes or no? Therefore, in that context of that social contract, if something is breached, that social contract will break down. Therefore, in any criminal case, any crime is therefore taken as an action against the state. So whenever you see this state, it's usually a criminal case against the state. Even if it is a murder case, for example, the state is a representative of the victim in that case, because state is protecting collectively the rights of all the people. With this context, understand this situation. There is a university called Ashoka University. One professor of that university, Mr. Ali Khan, in the context of the briefing given by our armed forces, Sophia Qureshi, she was giving the briefing. So he made a comment. Wherein he was talking about how the how the government is probably misrepresenting the situation of secularism in this country, and he made some comments. The women commission and the women groups in Haryana found this to be very objectionable, a very demeaning against the modesty of women. And secondly, they also found that these comments were inappropriate in a very sensitive situation where two countries are facing some trouble. When we are almost like in a warlike situation, those comments can fuel communal hatred. That's what they believed. So that professor was arrested, and usually bail would be given without any condition. But in this case, Supreme Court gave a bail on the condition that he doesn't speak anything. Okay. So the article writer, Mr. Pratap Bhanu Mehta, believes that this is against the constitutional values. This is against the rules established, the fundamental rights, and the whole concept of constitutional morality. Because bail is supposed to be unconditionally given. And Supreme Court is creating new precedents. It is setting new kind of examples. It is saying that, I can create law. The law does not have, according to Pratap Bhanu Mehta, the law does not have any provisions where court can say, I will give bail only on certain conditions. Okay. Now, this is the case. What is your counter, logical counter to Pratap Banu Mehta? If you were sitting in an argument with, can you think of an argument? Can you think? Can you try? Did you understand the case? See, there is one person who made a comment during the time of Operation Sindoor about how women are misrepresented, or Muslim women are being used by the Indian government to showcase secular feeling. And therefore, the people, the petitioners felt that this was offensive and also probably inciting hatred during a very sensitive time. And the court took cognizance of this case and said that, okay, this is not accepted. I'll give you a bail only on certain conditions. The writer believes that this is problematic because this is against the established procedure. Would you agree with the writer? Let's say you agree. Let's take two scenarios. Let's consider this like a game of chess. This skill is extremely important for you. Okay. On one hand, let's say you're playing the whites. You make a move and you also play the blacks. You make the counter. By doing this thought process from both the ends, you develop a critical skill of analysis. Analysis means logical counter. So see, this is not there in the article. You will not get direct information like this. Article writer will not write his counter view, right? So it's our responsibility to come up with a counter. Okay. No, let's not get into information of what Supreme Court said or what. What is your thought? I want your original thought to come out on basis of certain principles. Let's go. Till now, we have been repeating almost every day that state and individual are bound by a social contract, and the concept of state is dependent on sovereignty. If there is a possibility of any action affecting that sovereignty, judiciary as a protector of the constitution, is it not supposed to put restrictions? Is procedure more important or the cause more important? Okay, let's say there is no law right now. Okay, there is no law. Yes, the article writer is pretty much right on citing that we don't have a law at this point of time. But should we wait for a law to be created, argued, discussed, etc., meanwhile where there is a possibility of a communal tension in such a sensitive time? Should we not put a restraint? Is it too unreasonable to put a restraint on freedom of speech? Because the very Article 19 says that, Article 19 Clause 2 says that there can be reasonable restrictions on the basis of public order. First point itself says that public order and morality. Let's not get into the morality debate. But the first, public order, on the basis of that principle, can't we put a restriction? Maybe. Yes. To this extent, we can counter the writer and probably defend. But what we cannot defend is leaving the Supreme Court's order at just that gag speech. Gag speech means you are not allowed to speak something. This cannot be allowed indiscriminately. There should be a premise and condition under which judiciary should come up with this kind of orders. Otherwise, we will have to agree with what the article writer says. It will set a bad example. Okay, I agree now it is a very sensitive time. The Supreme Court had to take certain decisions. To that extent, we can agree. But it is not acceptable in normal times. But unless you codify it through a law, unless you uphold it through the procedural integrity, meaning if you want that to be a norm, like in every time such kind of a situation comes up, we need a proper framework of approaching that issue, right? It cannot be just as you wish, because that is not the job of judiciary. Creating laws is not the job of judiciary. It becomes a case of judicial overreach. Clear? Separation of powers concept is linked here. With this context, let us now look at the whole framework of justice, judicial interpretation, and the concept of liberty, and how to come up with a generative framework of points. How can we generate points in a logical way? This is the skill I want you to learn through this article. Okay? This article can be quoted as an example or an argument to defend your case. Is that clear? Did you understand the case completely? Clear? Okay. Now let's go back. What is the constitutional framework of liberty? What is liberty? Liberty means? Is liberty and freedom both same? What is liberty? Liberty and freedom are two associated concepts. Let's say, for example, if we go back to the origin of that concept. See, this is a political philosophy that we are talking about. In this political philosophy, freedom and liberty can be synonyms. Let us understand how this concept of freedom came first. What is the difference between, let's go back to the evolution time, Charles Darwin, Darwinian theory. Do you know what this is? Survival of the fittest. The reasons why human beings are considered to be the most superior species. Is there any reason why? Because of our ability to think. So, if you put an animal and a human being, obviously human being is considered on a higher pedestal. But if you put two individuals, both of them can think. Now what? Now if I stop one individual from thinking and only allow one, and he chooses not to think at all. This guy has the ability to think, but is not allowed to think. This guy has the ability to think, he is allowed to think, but he won't think at all. Do you want to encourage that kind of a society? What makes a person human? The ability to think. Right? So, freedom is the nature of a human being because you are free to think. This is the nature. You describe a human being by the amount of freedom they have to do something. Freedom of thought, therefore, is the fundamental right. Why is it called fundamental? Fundamental means something so basic without which you cannot exist. Human rights are called fundamental because without them, there is no difference between human beings and animals. Clear? That is the concept of freedom. Now, freedom is associated. This is a nature of human being. Now, liberty means in the political sphere, in the concept of the state, you are ascribing a certain amount of liberty to that individual as a part of the social contract. So, freedom is like the nature of human being. Whatever upholds that nature is associated with the concept of dignity of human beings, without which you cannot be human beings. But if the same concept is extended to your political participation, your political participation and participation in the idea of the state should be within the ambit of this political definition of a state. So, whatever activities come under a reasonable social contract, that is called liberty. Whatever empowers you to be a part of that state and develop becomes a part of that liberty. Okay? So, Article 21 enshrines the right to personal liberty, which encompasses fair bail jurisprudence. Okay? You have Article 19, which guarantees freedom of speech and expression. You have Article 19, Clause 2, which permits restrictions only on enacted laws on specific grounds like security or defamation. Okay? Enacted laws. Please be careful. Now let's talk about, you understood the case, you understood the principles of freedom, liberty. Now we are coming to an associated concept of constitutional morality, which is also a mains question in 2021. Define constitutional morality. This was a question. Where will you find this? In latest newspaper articles and also your NCRTs. Indian Constitution at Work. Basic chapter. The first chapter talks about a concept of constitutionalism. Okay? In that, the word constitutionalism means imposing a restriction on the powers of the state. Why are we imposing these restrictions? To safeguard liberties. Who is best placed in the entire three wings of our government? legislative, judiciary, executive. Among these three, who is most likely to protect? Judiciary. Judiciary is a protector of liberties. Okay. So this is constitutional morality's angle. Now, if judiciary is not doing that job, who will be able to do it? Nobody else. So that's the basic logical premise. Now, the whole doctrine of constitutional morality is premised on protecting constitutional values, and the role of judiciary in that is interpreting, not creating. Okay? And you have to balance law and liberty. These are the constitutional values which are relevant in the specific case. Clear? We are not only learning the concepts here, we are also learning the structure of how we have to present our argument. Once you understand how to structure your argument, you can condense it. You can condense it and present it in such a way that it is communicated in the shortest possible way. That is how you write your mains answer. So the training of writing a good mains answer starts from understanding the concept, reorganizing your thought, structuring an argument, condensing it, by-hearting it, writing, repeating. These are the steps. Clear? One by one. Okay? So, Dr. B.R. Ambedkar. Can you tell me what is the role of Dr. B.R. Ambedkar in our constitution? Okay. Drafting committee chairman. Go to making of constitution chapter, your homework for today. Please do it. Making of constitution, Lakshmikant. There are many committees. Okay. What is the role of these committees? I want you to by heart it. First, understand the role, what are the various committees and subcommittees, and within them, usually when you are reading for prelims, there are two committees which most people get confused about. Committee on Fundamental Rights and Minority Rights. This is not by Dr. B.R. Ambedkar. It is by someone else. Go and check who that person is. Any answer? Okay, go back and check. So, anyway, coming back. Constitutional morality, you understood the concept, right? Why does it matter for us to uphold this constitutional morality? What will happen if we don't care about it? We will structure the argument in the context of this case, because that is what the writer said. Firstly, the writer believes that it will set a very dangerous precedent, because preemptive censorship can establish a dangerous norm. Now you can quote national security situation and censor a person from freedom of speech. It might sound justified right now, but remember, when you're reading your concepts in judiciary, Supreme Court is called court of record. What does this word mean? Whatever judgments are pronounced by the courts, they can be used as a reference to structure your argument and logic in future cases also. What if next, somewhere down the line, 5 years down the line, a petitioner will quote this judgment and ask for a restraining order, or ask the court to stop someone from expressing their opinion. If you don't define what is the legal definition of anything, let's say for example here national security. What is the meaning of national security in this case? It is very clear now. If you are in a warlike situation, your fundamental rights will take a back seat, national security takes a front seat. But what if you are not in a warlike situation? It is not technically a war. Officially, we cannot call it a war. But there is an attack on the state of state of India. So it is a threat to our sovereignty. So we can interpret it as a state-sponsored terrorist activity against the sovereignty of this country. Right? But normal times, how do you define national security? Is there a law? That's a question mark. Right? So we need to create a law. When we say we the people of India having solemnly resolved. We, as in our representatives. So it is not the job of judiciary to make laws. It is the job of people through the representatives, through elected representatives. And that is the constitutional design to protect our interests. That is how the social contract will stay intact. Correct? Because there is no meaning to the concept of separation of powers. The whole design will get disrupted if judiciary starts making laws, and that is the main problem expressed by the writer. So this sets a dangerous precedent because Supreme Court is a court of record. Someone in the future can quote this case and say, please impose a restriction on the freedom of speech of someone. Fair enough argument. Now, judicial authority will be weakened according to the writer as an interpretation of what the writer says, because it will erode trust according to the writer. It will erode trust and weaken judicial authority, because if there is no law and judiciary is acting beyond it, it essentially is not sticking to the interpretation of the law, its main job. It is being subjective, which is dangerous. Chilling effect on democracy, because democracy depends on dissent. Dissent means the ability to criticize. If you are not allowed to criticize in a government, allowed to criticize a government, there is stagnation in the thought process. See, we are challenging the article writer to a certain extent, right? If you want to support him, how much can you support him? If you want to oppose him, how much can you oppose? This gives a very balanced approach to your thought process. Do not accept any thought absolutely. Your ability to make that sense of judgment is what makes you a good policy maker. Correct? Finally, the article writer says that assuming a legislative role may breach the constitutional separation of powers. See, if you want to say why this is bad, you need to use certain keywords which are premised on the principles established by our constitution. So these are the keywords: violates separation of powers, chilling impact on democratic processes, acting beyond the law weakens judicial authority, preemptive censorship can establish dangerous norms. Keywords. Complicated ideas are presented in short phrases. And for all of these points, if you want to write, see, this argument can be given for any case where there is a conflict between judiciary and executive. Same keywords can be used. And for all of such cases, you can use the same case. Ali Khan was the state of Haryana. Just write one example, that's over. This is how you have to use our newspaper articles. Now, you understood the framework of liberty. You understood the importance of doctrine of constitutional morality. You understood the case study. Now, you will understand one more concept called proportionality principle. Can anyone tell me what is this proportionality principle? Any limitation on fundamental rights must be rational, minimal, and necessary. 3 keywords that you have to focus on. Reasonable restrictions, Article 19, Clause 2. There is a philosophy behind that. That philosophy is called doctrine of proportionality. It should be rational. There should be a logic as to why we are imposing. Right? So let's take the case of this professor. Is there a logic from Supreme Court's end? Is there a logic? Yes, the logic is we are at a very sensitive time. So such comments need not be necessary at this point of time. That is our logic. Second, minimal. What do you mean by minimal? It should not be beyond what is. Let's say, for example, would you impose a death sentence for stealing, a matchbox? Oh, right. Sounds ridiculous, right? But what is ridiculous? What is not ridiculous? Who are we to decide? Whose job is it to set some standards? It is the job of both legislative and judiciary, and they should come to an agreement. See, you make a law. If you think this is not right, judiciary can say this is not valid on these principles. So there should be an agreed framework of approaching an issue. So that minimalism is a subject matter of debate. The debate that can be debated. So this is the reason why that vague, open-ended statements can cause lot of litigation. And necessary. Again, this is also open for debate. We believe it is necessary. The writer believes that it is not necessary. How can we settle this? So right now, since it is not having an adverse impact on the person who is asked not to speak up on this issue, it is reasonable till the situation is settled. But is it minimal? Is it necessary? This is a subject that we can debate about. And this is why there should be a conversation on the principle of proportionality. Okay? Whatever we do should be statutorily mandated. It is not subject to the wishes, whims, and fancies of any wing of the government, either legislative or judiciary. There should be a logic as to how you are doing this, right? That is the proportionality principle that you need to understand. So, since the article writer is talking about a case where this is judicial overreach, a concept where judiciary is acting beyond its jurisdiction. Let's say you have to stop here. You have to just interpret the laws. But no, judiciary decided that I will move beyond what I am mandated and I will reach into the domain of legislatures just because I want to protect the concept of sovereignty. This can be an argument. But what will happen if that continues to become a norm? It can only, see, can you always work on a emergency mode, like full vigilance, all resources deployed just to be safe? That's not an efficient way of functioning. Can you always work under stress? High stress levels. Can you study 15 hours a day for 3 years, 4 years? No. 3 days, 4 days? Yes. At least 1 month? Maybe yes, before prelims. But that is not sustainable. Any system cannot work beyond a threshold. When you are pushing it to the brink, it is not sustainable. So you need to know the concept of judicial overreach and its consequences. Firstly, there will be democratic erosion. Why? Because it is a job of MPs to create laws. And here you are making laws on behalf of legislature. Then what are the legislative houses for? It will lead to erosion of trust and democratic erosion. Because the quality of democracy depends on the amount of public will that is translated into action. Here there is no public will. That is not the job of judiciary. Second, it will weaken judicial authority. Okay? See, the reason why I am repeating all these points in different contexts is because you never know how question will be asked. Whether they will ask in the context of proportionality, whether they'll ask in the concept of judicial overreach, you don't know. You should be able to frame your argument in all these cases. That's why I'm asking this. Okay? Next up is separation of powers violation. And the same point, precedent setting. Like it will be a bad precedent. Same points you will be reworking and arguing depending on the way that question is posed. Okay? Now, what is the threshold for judicial intervention if the question is asked in the context of judicial overreach? Courts must satisfy necessity, legality, and proportionality tests. As simple as that. Okay? Understood? Now, what should be a balanced approach? Courts must defend liberties unless explicitly restricted by law. So, article writer says that we have to stick to law. How can we know? You should apply the legality test. There should be a clear statute. See, if the law says, let's say for example, BNS or IPC previously, there is something called section 153 in IPC. If that section says, okay, you can impose restrictions, then it is okay. If the section does not say anything like that, don't create, don't interpret. That is what the article writer says. They should have a very clear statutory basis. If there is no law, you should tell the logic as to why this action is taken, and that action should again be based on some other law. Without law, don't give any orders. That is what the article writer says, which is fair enough. You have to maintain neutrality. Courts should act as referees, that is umpires, and not regulators of public morality. See, time and again, you will notice that high courts will give one judgment, Supreme Court will give just the opposite of that. There were many controversial cases where, did we discuss this concept of transformative constitutionalism? No? Okay. To explain this point, I'll just tell you about that transformative constitutionalism also. See, if you take the history, of judiciary and how judiciary interpreted various cases from 1947 till present times, you can divide them into various contexts. In the initial days, Supreme Court directly translated whatever was there in the text. textual approach. Then there was a case where it started interpreting. And in the next phase, there was conflict between institutions because of this. In the present case, we are in something called a transformative phase of constitutionalism. What does this mean? Here, the focus is on social rights, individual rights. The court is using the authority of judiciary to transform society. Okay? To transform society. A case to the point being Sabarimala judgment. Women being allowed. So again, that's a very different debate. But in this transformative phase, the emphasis is on Article 14, individual liberty. Individuals are given priority over institutions. So this becomes a situation where the court is trying to teach the society through law elements of morality. For example, LGBT issue, same-sex marriage, all this are issues of public debate. Society may not be ready, but the courts should evaluate them based on certain principles. Equality, for example. When you want to treat them equally, what are the consequences? How should the society be like? How should the state act like? These are the kind of issues through which the courts will argue their logic. Clear? So, this issues of morality should again be only suggestion to the legislative. It should not be like the Supreme Court or any judicial body directly making laws. Finally, it should protect the constitutional values, safeguard rights while allowing lawful restrictions. Same thing, Article 19, Clause 2. Okay? Same content I am presenting in different contexts so that you learn how to present your answers. In one, we are using this timeline approach. See, this is one way of clearly or neatly presenting your argument. Here I am showing you presentation skill. This is not a concept. So you need all the skills that we discussed. Okay? Now, see, whenever you are reading any further issues in this concept of the conflict between the judiciary and legislative, there are other cases that will come up. Sedition and hate speech laws. What do you mean by sedition? Deshdrohi. You are termed Deshdrohi. So anything that betrays the social contract between an individual and the state, where you are backstabbing your own country, that is sedition. Hate speech. Anything that is said to incite violence or enmity between two groups. That groups can be formed on the basis of religion, region, caste, gender, whatever may be. If you are targeting someone, that is hate speech. But what is hate speech? What translates into hate speech? Should we prosecute them under hate speech? That's a whole different debate, which we will deal in future classes. But whenever these issues come up, please remember this whole explanation and the arguments that you have had. Next up is digital censorship. Someone makes a comment, some troll makes a comment on social media. Should we throw him in jail? If yes, why? If no, why? On what conditions we can put him out? On what conditions we can throw him in the jail? There should be some structure to that whole thought. That structure and thought is premised on proportionality doctrine, judicial restraint, not judicial overreach. It is the job of legislature to create those laws. For that aspect also, we can use the same framework of thought for approaching the issue. Preventive detection, Article 22. Any article that comes in the context of police reforms, preventive action, preventive detention, because we are directly imposing the limitations on liberty of the individual. On what conditions is it justified? What should be the role of the judiciary? In that context also, you can have a similar argument. With this, now let's go to the first slide. You can note this down. Yeah. You can use this framework, direct. This is the metric on which you can generate answers for all these issues that we have discussed. Okay. Firstly, whenever there is a conflict between judiciary and legislatures or executive, the first point that you can think of is doctrine of liberty. What is liberty? We have already discussed. Second, interpretation. How are we as in courts, how is a court interpreting this? Is it a case of judicial overreach or within the boundaries of the law? Second aspect, judiciary must not improvise moral codes, must act within the constitutional framework. Next is rule of law. Here you can talk about this judicial excesses, impact of exceeding your limit, your as in judicial limit. How will it undermine or reduce the respect judiciary has? Same logic goes for legislatures also. It is not the responsibility of judiciary to create laws, and legislatures cannot interpret as per its own wishes. It should be subject to the jurisprudence. Understand this word, jurisprudence. This word is very, very important in constitutional law. Constitutional law is a subject in law. Okay? Jurisprudence is also one subject. Jurisprudence means the logic that you use to judge whether a law is right or wrong. Okay? Next is constitutional morality. Where will you find constitutional morality totally? In preamble. So that's why you have to always by heart preamble. Okay? Whenever you are having a debate on this kind of issue, you should know clearly the threshold. Meaning, okay, you are now crossing the limit. Here is where judiciary should enter. You should have a clear-cut idea. What is the threshold? Restrictions must pass the tests of necessity, legality, and proportionality. We have discussed, right? Clear? This is the framework in which you can frame your argument. In the introduction, you will talk about Article 19, 14, and 21. The golden triangle. 14, 19, and 21. Most of the mains answers will be with respect to these three issues only. Take a look at the previous year questions. In short, you have actually covered most of the principles involved in previous year questions through this article. Clear? Now, if I give you a small question, what are the implications of judicial overreach? Examine. 10 marks. How will you write the intro of this answer for this question? What are the implications of judicial overreach? Examine. 10 marks, 150 words. What is the intro? You can use this case as an example, fine. But if you were to introduce in any context, like you don't know this case, you do not remember, the whole objective of this class is developing the skill to generate points. You know only concepts, you don't know the facts. Okay. Judicial overreach is a scenario where it breaches the limits of the law and it is beyond the threshold of necessity, doctrine of necessity, doctrine of legality, and doctrine of proportionality. If you write these 3 points, trust me, you will not lose any marks, even if you don't know the case. Then write, why is it a problem? This breaches the golden triangle of Article 14, 19, and 21. Fundamental rights, Article 14, 19, and 21. And put that in a triangle. And within the triangle, write breaches the golden triangle or breaches the limits of judiciary. Clearly, it will communicate that you know the concept. And if you know one step ahead, if you want to go one step ahead, example, write one case. Can be any case. Anything. Anything where there is probably judicial overreach. However, this has both positive and negative analysis. Write down positive points, negative points. It should clearly communicate visually that you know both positive and negative. You are not only blinded by one side only. And this is how you present your answers. Anything. You can put anything. That can be conclusion. Conclusion. See. How to structure your argument. Like I told you, A, because you are arguing in your body, therefore C which is conclusion. Clear? A because B, therefore C. What am I saying as an assertion? Judicial overreach is not good for democracy because these are the points. Therefore, we should uphold the, what is the logic here? What should be the ideal? So you are writing norms, normative. Normative means, what do you mean by norm? It is the ideal situation. In the ideal situation, what are you trying to do? You are trying to showcase to the world, if we respect this principle, how will the world look like? When we say you should always write positive conclusions, why are we writing positive conclusions? There should be a logic, right? The positive conclusion will tell us the benefit of respecting that principle and how the world would look like if we respect that principle. That is the logic of writing this. Clear? This completely covers the concepts of judicial overreach and how to structure your answers for mains, how to take content from any newspaper article within the ambit of this framework. Clear? No matter which article, where you read, how you read, if you remember this concept, you will be able to master newspaper reading. Clear? Great.